The termination paperwork was dated March 14th. The safety violation they cited happened on March 22nd. I noticed it immediately when HR slid the folder across the table. 8 days. They'd fired me for something that hadn't happened yet. My name is Claire. I'd managed second shift production at Halstead Manufacturing for 6 years. I knew every machine on that floor, every worker, every protocol. I knew how to read documents, too. The operations director sat at the end of the conference table with his arms crossed. David Kramer. 15 months in the role. He'd transferred from corporate with ideas about efficiency and modernization. Most of them involved cutting experienced staff and replacing us with contractors. "The date's wrong," I said. He didn't look up from his phone. "Administrative error. The incident date is what matters." "The incident date is after you filed termination." "Miss Hayes, we're not here to debate paperwork. You endangered workers by overriding the lockout-tagout system. That's grounds for immediate dismissal." I hadn't overridden anything. The maintenance log would prove that. But I didn't say that yet. HR cleared her throat. Jennifer Park. We'd worked together before Kramer arrived. She wouldn't meet my eyes now. "Claire, if you sign the separation agreement today, the company is prepared to offer 2 weeks severance. If you contest this, that offer is withdrawn." 2 weeks. After 6 years. I looked at the paperwork again. The signature on the safety report wasn't mine. The handwriting was close, but the lowercase a was wrong. I always looped mine. This one was printed. "I need time to review this," I said. Kramer finally looked up. "You have until end of business today. After that, we move forward with cause, and you leave with nothing." I took the folder. I didn't argue. I walked back to my office and closed the door. Then I opened my desk drawer and pulled out my own records. I'd kept copies of everything since Kramer arrived. Not because I expected this, because I'd learned early in my career that memory isn't evidence. The maintenance log from March 22nd was in my files. Signed by me. The real signature. The lockout-tagout system hadn't been overridden. It had been scheduled for replacement. I'd submitted the work order myself in February. I photographed every page in the termination folder with my phone. Then I photographed my own records. The work order, the maintenance logs, the shift reports from the week in question, the email chain with the safety equipment vendor. Each photograph was clear, dated, time-stamped by my phone's metadata. I sent them to my personal email in 3 separate messages. Then I checked that they'd arrived. Then I deleted them from my phone. It was 11:40 when I finished. I had until 5 to sign. I pulled up my contact list. I had the name of an employment attorney saved from 2 years ago. A friend had used her for a wrongful termination case. The case had settled in 6 months. I called the number. "Gallagher Law Group. I need to speak with Rita Gallagher. It's regarding a termination." "Is this an existing client?" "No, but it's urgent." There was a pause. Typing. "She has an opening at 3 this afternoon. Can you make that?" "Yes." "Name?" "Claire Hayes." More typing. "We'll see you at 3. I hung up. I didn't go back to the conference room. I didn't call Kramer. I gathered my personal items from my office. A coffee mug, a framed photo, a plant someone had given me 3 years ago. Then I drove to the copy center 3 miles from the plant. I printed everything twice. Every photograph, every document, every email. The packages were thick, heavy. One set went into a safety deposit box at my bank. The other went into a folder in my trunk. Then I drove to Rita Gallagher's office and waited in my car until 2:45. Her office was on the 3rd floor of a building downtown. The receptionist took my name and asked me to wait. Rita came out at exactly 3. She was in her 50s, gray suit, No jewelry except a watch. Ms. Hayes? Yes. Come with me. Her conference room had a long table and nothing else. No art, no plants, just the table and chairs and a window overlooking the parking lot. Tell me what happened, she said. I laid out the documents, the termination letter, the safety report, my own maintenance logs, the work order from February. She didn't interrupt. She read every page. 7 minutes passed. Then she looked up. They forged your signature. Yes. And they filed termination paperwork for an incident that occurred 8 days after the filing date. Yes. Did you override the lockout-tagout system? No. The system was flagged for replacement. I submitted the work order in February. The vendor confirmed receipt. Installation was scheduled for March 28th. She tapped the termination letter with one finger. This severance offer expires at 5 today. I know. If you don't sign, they'll proceed with the for-cause termination. No severance, no unemployment eligibility. They'll contest any claim you file. I understand. She leaned back in her chair. What do you want? I want them to answer for this. Rita checked her watch. It was 3:20. Then don't sign. Let the deadline pass. They'll file the for-cause termination tonight or tomorrow morning. Once they do that, they've locked themselves into a position. They can't walk it back without admitting the original paperwork was false. And then? Then we file a wrongful termination claim in civil court. We include the forged signature, the impossible timeline, the work order they're pretending doesn't exist. We request discovery. We depose everyone involved, and we let them try to explain it under oath. How long does that take? 6 months if they settle early, a year if they fight, longer if they appeal. What do I do until then? You document everything, every email, every call, every interaction. You apply for unemployment immediately. They'll contest it, you appeal, and you find another job if you can. I nodded. What do I owe you? Nothing today. If we take the case, I work on contingency. I get a percentage of whatever we recover. If we lose, you pay nothing. What percentage? 33%. I thought about it. Not for long. Okay. She pulled a contract from a folder and slid it across the table. I read it. 3 pages, standard contingency language. I signed it. Good, she said. Now go home. Don't answer calls from Halstead. Don't respond to emails. Don't sign anything. If they contact you, forward it to me immediately. I left her office at 4. I didn't go back to the plant. I didn't call Jennifer Park. I didn't call Kramer. I went home and waited. At 5:30, Jennifer sent an email to my personal account. Claire, since you did not return the signed separation agreement by the deadline, your employment has been terminated for cause effective immediately. Your final paycheck will be processed on the next regular pay date and will reflect deductions for unreturned company property. Your health benefits end today. Please return your security badge and any company materials to HR by end of business Friday. I forwarded it to Rita. She replied in 2 minutes. Perfect. This makes everything easier. I didn't ask why. I assumed she'd tell me when it mattered. The first week was strange. I'd worked second shift for 6 years. My body woke up at noon. I made coffee at 1. I was alert by 3 and ready to work by 4. Except I had nowhere to go. I filed for unemployment on day 3. The application asked if I'd been terminated for misconduct. I selected no. It asked for details. I wrote 1 sentence. Employer filed termination for an incident that occurred after the termination date. The claim was denied 4 days later. Your claim has been denied. Halstead Manufacturing reports you were terminated for cause due to safety violations. You may appeal this decision within 21 days. I called Rita. I got the denial, I said. Expected. File the appeal. The hearing will be scheduled in 4 to 6 weeks. I'll represent you. Do I need to prepare anything? No, just bring copies of everything you gave me. The state referee will review the evidence and make a determination. If we win, you'll get unemployment benefits retroactive to your filing date. If we lose, we proceed with a lawsuit anyway. What are the chances we win? High. They filed termination paperwork before the incident occurred. That's not a gray area. That's fraud. I filed the appeal that afternoon. The confirmation email said a hearing would be scheduled within 6 weeks. Then I waited. Rita filed the wrongful termination lawsuit on day 12. She didn't tell me she was filing. She just sent me a copy of the complaint after she'd submitted it to the court. It was 32 pages, single-spaced. Every paragraph was numbered. Paragraph 8 detailed the forged signature. Paragraph 12 detailed the timeline discrepancy. Paragraph 19 included photographs of the work order I'd submitted in February. Paragraph 24 included the vendor's confirmation email. The complaint requested damages: back pay, front pay for 2 years, emotional distress, punitive damages, attorney fees, and it requested all internal communications related to my termination. I read it twice. Then I called Rita. You didn't tell me you were filing. You hired me to handle this. I'm handling it. What happens now? Now they respond. They have 30 days. Their corporate counsel will file an answer. They'll deny everything. Then we'll request a discovery schedule from the court. Discovery? Interrogatories, requests for production, depositions. We ask for every email, every memo, every text message related to your termination. They have to provide it. If they don't, we file a motion to compel. If they still don't comply, the judge sanctions them. How long does discovery take? 3 months minimum, 6 months if they slow walk it. And then? Then we depose Kramer. We depose Jennifer Park. We depose whoever created that safety report. And we see if their story holds up under oath. I thanked her and hung up. Then I started looking for work. The contract job came through in week 4. A logistics company needed someone for inventory management. 3rd shift. Temporary placement with possible permanent hire. It paid $18 an hour. I'd been making $62,000 at Halstead. I took it. The unemployment hearing was scheduled for May 6th. Video conference, 10 a.m. Rita called me the night before. The referee will ask questions. Answer them directly. Don't volunteer information. Don't speculate. If you don't know something, say you don't know. Will Kramer be there? No. Jennifer Park will represent Halstead. She'll bring the safety report. She'll claim you overrode the system. I'll cross-examine her. It won't take long. How do you know? Because she can't explain the timeline, and she can't explain your signature. The hearing started at 10 exactly. The referee was a woman in her 60s. She introduced herself as Magistrate Carolyn Weston. She explained the process. Halstead would present their case. I would present mine. Then she'd ask questions. Jennifer Park appeared on screen. She was alone in a conference room. She looked tired. Ms. Park, please state your position. I'm the Human Resources Director at Halstead Manufacturing. And you're here representing Halstead in this unemployment appeal? Yes. Please explain the basis for Ms. Hayes' termination. Jennifer pulled out a folder, the same folder from the termination meeting. Ms. Hayes was terminated for cause on March 14th due to a serious safety violation. She overrode the lockout-tagout system on one of our production machines, which endangered multiple workers. This is a direct violation of company policy and OSHA regulations. Magistrate Weston made a note. When did this violation occur? March 22nd. And when was the termination filed? Jennifer hesitated. March 14th. So the termination was filed 8 days before the violation occurred? Jennifer didn't answer. Ms. Park, I'm not asking about the incident date. I'm asking how Halstead filed termination paperwork for an incident that hadn't happened yet. Jennifer didn't answer. Magistrate Weston looked at her screen. Ms. Park? I don't have an explanation for the date discrepancy. Did you verify the dates before processing the termination? I relied on the documentation provided by the operations director. Who is the operations director? David Kramer. And he provided the safety report? Yes. Did you independently verify the information in that report? No. Magistrate Weston made another note. Then she turned to me. Ms. Hayes, did you override the lockout-tagout system on March 22nd? No. Do you have documentation to support that? Rita shared her screen. The work order from February appeared, then the vendor confirmation email, then the maintenance log from March 22nd showing the system was operational and had not been overridden. Magistrate Weston reviewed each document. 3 minutes passed. Then she looked up. Ms. Park, does Halstead dispute the authenticity of these documents? I'd need time to review them with our legal team. That's not what I asked. Do you have evidence that these documents are false? No. Do you have evidence that Ms. Hayes overrode the lockout-tagout system? We have the safety report. The safety report that was dated before the incident allegedly occurred? Jennifer didn't respond. Magistrate Weston closed her folder. I'm reversing the denial. Ms. Hayes is eligible for unemployment benefits effective from her filing date. Halstead Manufacturing, you'll receive a written decision within 10 business days. This hearing is concluded. The screen went black. Rita stayed on the call. That's one. One what? One piece of evidence they can't explain. The unemployment decision is public record. Halstead's corporate counsel will see it. They'll know their HR department just committed fraud on a state record. What does that mean? It means they'll want to settle. Soon. She was right. Michael Strauss called Rita's office on May 8th. He was Halstead's corporate counsel. He wanted to discuss resolution options. Rita told him we'd consider settlement offers in writing only. No phone calls? He asked. No phone calls. Why not? Because I want everything documented. If you want to settle, put it in writing. Include the terms, include the amount. We'll review it and respond. He said he'd send something within a week. The offer arrived by courier on May 15th. Rita forwarded it to me with no comment. I read it twice. Halstead would pay 12 months back pay. They would provide a neutral reference. They would remove the for-cause designation from my employment record. I would sign a non-disclosure agreement. I would dismiss the lawsuit with prejudice. I would not disparage Halstead or any of its employees. The number was $52,000, minus taxes. I called Rita. What do you think? She asked. It's not enough. What do you want? I want them to answer for the forgery, for the timeline, for trying to erase 6 years of work with fake paperwork. Then we continue to discovery. We depose Kramer. We depose Jennifer. We get every email, every memo, every text message that led to this decision. But that takes time. Another 4 months minimum, maybe 6. I'm not in a hurry. Good. Neither am I. We declined the offer in a 3-sentence letter. Rita requested a discovery schedule from the court. The judge set a deadline for August 31st. All discovery had to be completed by then. Strauss filed a motion for mediation. He wanted a neutral third party, binding arbitration, anything to avoid depositions. Rita opposed the motion. Her brief was 4 pages. Defendant seeks to avoid discovery after submitting falsified documents to this court and to the State Unemployment Board. Mediation is a courtesy extended to parties negotiating in good faith. Defendant has not negotiated in good faith. Defendant has forged plaintiff's signature, fabricated incident dates, and provided false testimony under oath. Mediation is denied. The judge agreed. Discovery would proceed as scheduled. Rita sent interrogatories to Halstead on May 22nd. 28 questions. Each one required a written answer under oath. Question 6. Who created the safety report dated March 22nd? Question 9. Who signed Claire Hayes' name on the safety report? Question 12. Explain the 8-day discrepancy between the termination filing date and the incident date. Halstead had 30 days to respond. Their answers arrived on June 28th, 1 day before the deadline. Every answer was careful, evasive. Question 6. The safety report was prepared in accordance with company policy. Question 9. Halstead disputes that any signature was forged. Question 12. The date discrepancy was a clerical error that does not affect the validity of the termination. Rita read through them twice. Then she called me. They're not answering. I noticed. That means they're scared. They can't admit who forged the signature because that person committed fraud. They can't admit the timeline is wrong because that proves wrongful termination. So they're hiding behind vague language and hoping we don't push. What do? We push. I'm filing a motion to compel better answers. And I'm scheduling depositions. The motion to compel was filed on July 1st. The judge granted it on July 8th. Halstead had 14 days to provide complete answers or face sanctions. Their supplemental answers arrived on July 20th. Question 6. The safety report was created by Operations Director David Kramer based on his review of the incident. Question 9. No response at this time pending further investigation. Question 12. The termination paperwork was prepared in advance as part of standard HR procedure. The incident date reflects when the violation was confirmed. Rita called me after she read them. They just admitted Kramer created the report. Is that important? It means he's responsible. If the signature is forged, he forged it. If the dates are wrong, he falsified them. Everything points back to him now. What about Jennifer? Jennifer signed off on paperwork Kramer gave her. That's negligent, but it's not fraud. Kramer created the documents. That's fraud. The deposition schedule was set in late July. Jennifer Park was scheduled for August 2nd. David Kramer was scheduled for August 12th. Jennifer's deposition was held at Rita's office. I wasn't allowed in the room, but Rita recorded it with a court reporter. It lasted 4 hours. Rita called me that evening. She broke. What do you mean? She admitted Kramer handed her the safety report, already completed. She admitted she didn't verify the signature. She admitted she didn't check the maintenance logs or interview any shift workers. She admitted she signed the termination paperwork because Kramer told her it was urgent and time-sensitive. Did she know the signature was forged? She says no, but she admitted she never compared it to your actual signature. She just assumed it was real because Kramer presented it as real. So she was negligent. Extremely. But more importantly, she confirmed Kramer created everything. The safety report, the timeline, the documentation. It all came from him. What happens now? Now we depose Kramer, and he has to explain how he created a safety report for an incident that hadn't happened yet. And he has to explain where your signature came from. I asked when the deposition was scheduled. August 12th, 10 days. Kramer's deposition didn't happen on August 12th. Strauss called Rita at 7:50 a.m. that morning. Mr. Kramer is unavailable. Unavailable how? Medical leave. Effective when? Yesterday. Rita didn't raise her voice. We've had this deposition scheduled for 3 weeks. You're telling me he went on medical leave the day before? That's correct. I'll need documentation, medical records, a doctor's note, proof of the leave. That's privileged health information. Then we'll file a motion to compel. Mr. Strauss, your client created fraudulent documents and submitted them to the court. He doesn't get to hide behind medical leave. My client is entitled to privacy. Not when he's a defendant in a fraud case. You have 48 hours to produce documentation, or we're moving forward with the deposition in absentia. Strauss hung up. Rita filed the motion to compel that afternoon. The hearing was scheduled for August 18th. But on August 16th, Strauss called again. We'd like to discuss settlement. Rita put him on speaker. I was in her office reviewing documents. We declined your previous offer, Rita said. We're prepared to make a better offer. How much better? Substantially, but I'd like to discuss it in person. No, put it in writing. We'll respond within 48 hours. There was a pause. I'll send something today. The offer arrived at 3 p.m., hand-delivered by courier. Rita opened it and read it aloud. 18 months back pay. Full benefits continuation for 12 months. A neutral reference letter stating I left in good standing. Legal fees. Removal of the for-cause designation from all employment records. The total was $97,000, plus $42,000 in legal fees. The NDA remained. I couldn't discuss the case. I couldn't discuss the settlement terms. I couldn't discuss Kramer or the documents. But there was no admission of wrongdoing. What do you think? Rita asked. It's more, but it's still them paying me to go away. That's what settlements are. I know. She set the offer on her desk. You have options. We can accept this, we can counter, or we can proceed to Kramer's deposition and see what happens. What do you think happens if we depose him? One of two things. He lies and we catch him in perjury. Or he tells the truth and admits he falsified everything. Either way, it strengthens our case. But it also means 6 more months of litigation minimum. Maybe more if they appeal. I thought about it. Not for long. Counter. With what? 24 months back pay, 18 months benefits, full legal fees. And I want a clause that says if they retaliate against Jennifer Park or any other witness in this case, the NDA is void and the settlement is forfeit. Rita raised an eyebrow. They won't agree to the retaliation clause. Then we depose Kramer. She wrote it down. Anything else? I want the neutral reference to specifically state I was not terminated for cause. Done. She drafted the counter that afternoon. It was sent to Strauss at 4:30. He didn't respond for 3 days. On August 19th, he sent a one-line email. "We're reviewing your counter with our client." Another week passed. I worked my inventory shifts. I waited. I didn't call Rita. I didn't push. On August 26th, Strauss sent a revised settlement agreement. Rita forwarded it without comment. I opened it. 24 months back pay. 18 months benefits. Full legal fees. The neutral reference with specific language that I was not terminated for cause. And the retaliation clause. Exactly as I had requested. The total was $124,000, plus $46,000 in legal fees. The NDA remained, but everything else was there. I called Rita. They agreed. I see that. Why? Because deposing Kramer is worse than paying you. If he lies, they're facing criminal fraud charges. If he tells the truth, they're admitting to wrongful termination and forgery. Either way, they lose. So this is it? This is it. If you sign, the case is over. You get paid within 30 days. The for cause designation is removed, and you move on. What about Kramer? What about him? Does he face any consequences? Not from us. But Halstead's corporate counsel knows what he did. They know he forged documents. They know he lied to HR. They know he exposed the company to a 6-figure settlement. That's not nothing. I read the agreement again. Every page. Every clause. Then I signed it. Rita countersigned as my attorney. She sent it to Strauss on August 27th. The payment cleared on September 14th. $124,000. After taxes, it was $88,000. I'd made $62,000 a year at Halstead. The settlement was nearly 18 months of salary. I didn't celebrate. I didn't tell anyone except Rita. I just deposited the check and went to work. The contract job at the logistics company ended in October. They offered to convert me to permanent staff, but the pay was still low, $19 an hour with benefits. I thanked them and declined. I found a new position 2 weeks later, production supervisor, night shift, a manufacturing facility in the next county. They made industrial equipment. The pay was $68,000. The interview was straightforward. They asked about my experience, my certifications, my approach to safety and team management. They didn't ask why I left Halstead. I gave them the neutral reference letter Rita had negotiated. It was on Halstead letterhead, signed by Jennifer Park. Claire Hayes was employed at Halstead Manufacturing from March 2017 to March 2023 as second shift production manager. During her tenure, Miss Hayes demonstrated strong leadership and operational knowledge. She left the company in good standing and was not terminated for cause. We would rehire her if a suitable position became available. The hiring manager read it and nodded. When can you start? 2 weeks? Perfect. I started on November 1st. The facility was smaller than Halstead, cleaner. The management team was older, more experienced. On my first night, I introduced myself to the crew. I walked the floor. I reviewed the maintenance logs. I checked the lockout-tagout protocols. I asked about incident reports and safety audits. Everything was in order. At the end of the shift, the plant manager stopped by my office. How was your first night? Good. The team knows what they're doing. They've been waiting for someone with your experience. We've had some turnover in the past year. It's been hard to find qualified supervisors. I nodded. I didn't ask why they'd had turnover. It wasn't my business yet. He turned to leave, then stopped. One more thing. We take documentation seriously here. Maintenance logs, shift reports, incident tracking. I saw you were already reviewing them. I keep good records. He smiled. That's exactly why we hired you. He left. I locked my office and walked to my car. The parking lot was quiet. The night air was cold. I thought about the termination paperwork with the wrong dates, the signature that wasn't mine, the 2-week severance they'd offered to make me disappear quietly. I thought about Jennifer Park in the unemployment hearing, unable to explain the timeline. I thought about Kramer's deposition that never happened because he suddenly needed medical leave. I thought about the settlement check and the neutral reference letter and the for-cause designation that no longer existed. I got in my car and started the engine. I checked the company website for Halstead Manufacturing 1 week later, just out of curiosity. David Kramer was no longer listed under leadership. His name was gone from the directory. No announcement, no press release, no transition notice. I called a former coworker who still worked second shift. What happened to Kramer? He's gone, left in September. They said it was voluntary, but nobody believes that. Why not? Because he cleaned out his office after hours, didn't say goodbye to anyone, just gone. What about Jennifer? Still here, but she's not in HR anymore. They moved her to compliance auditing. She reviews paperwork now, doesn't make decisions. I thanked her and hung up. Rita called me in late October. She'd been contacted by another attorney. A former Halstead employee was filing a wrongful termination claim against the company. The circumstances were similar to mine: falsified documentation, timeline discrepancies, Kramer's involvement. They wanted to know if you'd be willing to provide a statement, Rita said. What kind of statement? Just confirming your experience. The settlement agreement doesn't prevent you from testifying about facts if you're subpoenaed. Will I be subpoenaed? Probably not. But the other attorney wanted you to know the option exists. I thought about it. If they subpoena me, I'll testify. That's all I needed to know. She also told me there was a third case, another former employee, another wrongful termination, another connection to Kramer. You weren't the first, she said. I know. And you probably won't be the last. I know that too. We hung up. I didn't follow up on the other cases. It wasn't my fight anymore. I focused on my new job, on my team, on the maintenance schedules and safety audits and shift reports. I kept good records. I documented everything. I signed my name the same way I always had. One afternoon in December, the plant manager called me into his office. I got a reference call about you last week, he said. From where? Another manufacturing facility. They wanted to know about your work. I didn't ask which facility. What did you tell them? I told them you're one of the best supervisors we've hired in years. I told them we'd be sorry to lose you if they made an offer. They didn't make an offer. Good, he smiled, because I'd like to talk to you about a promotion. Day shift operations manager. It's a salary position. More responsibility, better pay. How much better? $78,000, plus bonus eligibility. I didn't need time to think about it. Yes. Great. We'll start the transition in January. I left his office and walked back to the floor. The machines were running. The shift was progressing. Everything was documented. I thought about Halstead, about Kramer and the forged signature and the impossible timeline. I thought about the settlement and the neutral reference and the way my name had been removed from their termination records. I thought about how some people believe revenge is loud, a confrontation, a public scene. But the best revenge is a clean record and a better job, and a name that disappeared from a company directory without explanation. Justice doesn't announce itself. Sometimes it just deposits in your bank account and lets you move on. I walked back to my office and started my shift report. The date was accurate. The signatures were real. The timeline made sense. And that was enough.